Good day, Crime Talk aficionados. We have a great show for you today. First on the docket, a verdict in the Hunter Biden case. What does it mean? The Karen Reed trial gets a little awkward. An attorney in the Young Thug case is arrested for asking the judge why he was meeting with the prosecutor and a witness in chambers without all the other defense attorneys. Barry Morphew's prosecutor gets her day in court, and a Parent of the Year contestant and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Couple of quick public service notes here. First, we go live 6 p.m. Mountain Time for our Tuesday night live program. And immediately following that, we will have our Patreon show. If you haven't become a Patreon, please do so. Now, this is going to be an interesting show tonight, ladies and gentlemen. Why? Because Frank, the hardest working man in show business, he is turning the reins of all the technology over to me. We're going to see how this works out. Join us. That in and of itself ought to be worth a few minutes of your time. Join us, 6 p.m. Mountain Time. All right, let's go ahead and get to the docket. Let's go ahead and open the record for June 11th, 2024. And first on the docket, yes, a conviction in the Hunter Biden case. He has now been convicted of federal firearms charges. So a 12-person jury on Tuesday morning convicted Hunter Biden of all 3 counts against him following his federal gun trial. Now, obviously, Hunter Biden is the child of the sitting president, and he was found guilty of lying to a federally licensed gun dealer, lying on a federal form, and possessing a firearm while using or being addicted to a controlled substance. The prosecutor stated, ultimately, this case was not just about addiction, a disease that haunts families across the United States, including Hunter Biden's family. That was according to the special prosecutor, David Weiss. Now, he's the one that brought the charges against Hunter Biden. He said this case was about the illegal choices the defendant, Mr. Biden, made while in the throes of addiction. His choice to lie on a federal firearm form when he bought the firearm, and the choice of then possessing the gun. It was these choices and the combination of guns and drugs that made his conduct dangerous. Now, the special counsel Weiss also reiterated that no one is above the law, adding that Mr. Biden should be no more accountable than any other citizen convicted of the same conduct. Now, following the conviction, Hunter Biden released a statement expressing gratitude for those close to him, including his wife, Melissa Cohen, who was there at the trial the entire time. His statement said, "I am more grateful today for the love and support I experienced this last week from Melissa, my wife, my family and friends, and my community, and I am disappointed by the outcome," he wrote. "However, recovery is possible by the grace of God, and I am blessed to experience that gift one day at a time." Now, Hunter Biden's lead defense attorney, Abby Lowell, high-powered, super expensive attorney, probably charging several $1,000s per hour for his time, said, hey, obviously, naturally, we're disappointed by the guilty verdict, but respect the jury process, and we will pursue all legal challenges that are available. Obviously, what that means is an appeal. It also means sometimes no matter how good your attorney is, no matter how expensive they are the facts. Now, obviously, as you remember, this case originally started out, Hunter Biden was charged, there was going to be a plea deal. The judge said, hey, I'm not sure you have really thought this out as far as what this covers. There was not an agreement between the parties, so the judge said, let's move the case forward. Hunter Biden's sweetheart deal went away. And what I mean by a sweetheart deal, gun charge, he was giving basically a deferred prosecution. Never happens in federal court. In fact, I even asked a U.S. attorney at that time, and I said, can I get the Hunter Biden special? And he laughed in my face. So it was a sweetheart deal. Sometimes this is what happens, and sometimes you got to just go try the case. The judge handling the case, U.S. District Court Judge Mary Ellen Norica, set a tentative sentencing date for about 120 days out. Now, Hunter Biden faces a maximum penalty of up to 125 years, and let's get realistic, that is not going to happen. There will be a pre-sentence investigation report prepared as it is always done in the federal system. There will be a calculation under the federal sentencing guidelines, which will be a starting point. Years ago, that used to be it. You didn't get to argue anything else. Just simply what was on the guidelines. You did the little chart and you came down and that was your sentence. That was it. But the Supreme Court said the federal sentencing guidelines are only one of many factors that the court should consider. The other factors being the 3553A factors under 18 United States Code, which basically says that the court should consider the character of the individual, the crime in and of itself. We don't want to avoid giving somebody a more lenient sentence for similarly situated people. And basically, do we need to punish somebody, rehabilitate them, and provide them any treatment that obviously they need necessary? So, could he get probation? I haven't run the guidelines on this, but maybe I'll try to by tonight. Probably he's in the lower zones. He could possibly get some sort of in-home confinement, i.e. or a halfway house, up to a couple of years possibly in prison. Given the fact of the age of this case, given the fact that he only possessed the firearm for 11 days, given the fact that he has since gone to rehab, apparently staying clean and sober, I cannot imagine the court wanting to send him to prison for a lengthy period of time, only to set him back in his rehabilitation. Now, whether you like Hunter Biden or not, that's just the way it is. And the reality of it is, really, I understand there's going to be people that say, yay, Hunter Biden, their family's all criminals, good. Listen, when people are convicted, I don't care. I understand, when the serial killer is convicted, people are like, hey, I'm glad justice worked out. But it's never really a good day, right? On the prosecution side, you have victims that they have, maybe they get some justice out of it, but it's not like they're going to get their loved one back if it's a murder. Even on the defense side, somebody's going to prison. Somebody's life is going to be potentially forever changed. And not just the defendant, but his family, his kids. It's never a good day when you have to go to court, ladies and gentlemen. It really is not a good day. So, jumping back to old Hunter Biden, prosecutors originally alleged that he lied about his drug use on the federal form when he purchased a Colt Cobra 38 special revolver back on October 12th of 2018 at a gun shop in North Wilmington. Now, the trial lasted only 7 days, but Hunter Biden has really kind of dragged this case out since early June of 2023 when the first charged in this case. Now, that month, he and the Justice Department began discussing a plea deal that would have allowed Biden an opportunity to avoid criminal prosecution altogether. Sweetheart deal. However, those talks stalled after the judge raised several questions about the deal's logistics, highlighting stark differences between the prosecutors and the defense attorneys over the possibility of immunity provisions and what that in fact covered. Now, the two sides couldn't find a compromise, and Hunter Biden was formally indicted in September of 2023. His counsel repeatedly submitted motions to throw out the indictment between then and the trial's June 3rd start date, but the judge rejected all of those motions. Like I said, prosecutors had no shortage of evidence for their case, in large part due to Hunter Biden's openness about his own earlier drug use. Prosecutors played about an hour of Hunter Biden's self-narrated memoir, Beautiful Things, using his own words against him to paint a picture of a year-long crack cocaine addiction between 2015 and 2019. Additionally, prosecutors presented several text and WhatsApp messages obtained from both Hunter Biden's iCloud account and through his laptop, which was left at a Delaware computer repair shop back in 2020. Some people called it misinformation. In fact, 51 top intelligence agencies, leads, heads said it was Russian misinformation, only to be confronted with the truth when the DOJ in this trial had to say it was all accurate. Anyway, some of those texts contained coded language such as baby powder, party favor, and chore boy, which expert witnesses and drug enforcement agents testified were references to cocaine and other paraphernalia. Other messages were a little more explicit. In one message sent on October 13th of 2018, one day after Hunter Biden purchased the revolver, he wrote about waiting for a dealer named Mookie at a 7-Eleven parking lot. In another message sent a day later, he wrote he was sleeping on a car smoking crack. Now, the prosecution's case also relied heavily on testimony from Hunter Biden's former partner, who attests to his longstanding crack addiction before, during, and after the time that he bought the firearm. Zoe Keston, his ex-partner, testified to Hunter Biden's consistent crack smoking habit from when she met him back in 2017 through 2018, including on September 22nd, less than 3 weeks before he purchased the firearm. Hallie Biden, Hunter Biden's sister-in-law and former girlfriend, that's right, Hunter Biden's brother passed away, Beau. He went to comfort his sister-in-law, and they had a relationship. Oh, and he also got her to smoke crack that she testified to. Dark day for that family, seriously, for Hunter Biden to basically say, let's go to trial so that we can put all these people on and air all their dirty laundry out. Seems like it'd be easier just to take a guilty plea and avoid that trial tax of 3 points on the federal sentencing guidelines. Anyway, she told the jury she was cleaning Hunter's pickup truck that morning as he slept in her Delaware home. As they inspected the car's interior, she discovered the revolver stashed in the truck's unlocked console, along with bullets, remnants of crack cocaine, and drug paraphernalia. Hallie Biden quickly placed the gun and bullets in a pouch before throwing it out at a nearby grocery store trash can. Within hours, a can collector going through the trash cans found the gun and took it home, later returning it to police, who left it in storage for years before it would become the key evidence in the FBI investigation into Hunter Biden's case. Now, representing Hunter Biden in court, defense attorney Abby Lowell repeatedly emphasized that the prosecution's very high burden of proof, telling jurors during closing statements that the prosecution had played a magician's trick by diverting attention to the months and years before Hunter Biden's firearm purchase, and they blurred all those years together. Now, during cross-examination, Mr. Lowell suggested that data showing Mr. Hunter Biden near daily $100 or $1,000 ATM withdrawals didn't equate to amount of that of a typical drug user, and the agents quickly corrected Lowell, stating that to the court that the withdrawals actually do match what could be expected of an addicted person. Well, anyway, Mr. Lowell asked the agents throughout the cross-examination if Hunter Biden ever sent messages using coded drug language between August and November of 2018. Well, they agreed that Hunter Biden had not done so. He added that between October 13th, texts about waiting for a dealer named Mookie and 14 texts that said he was sleeping on a car smoking crack were so explicit they didn't require any interpretation, i.e. no coded language. He was just telling people what he was doing. What do I say, ladies and gentlemen? It's always the defendant's own words that get them. Hunter Biden also faces 9 federal tax-related charges, including tax evasion. He has pled not guilty to all those counts and obviously is given the presumption of innocence. That trial is scheduled in California in September. So, significance of this case is obviously it's the first time a president's child has been convicted of a crime of this nature. Second, it shows don't do drugs, kids. It'll destroy your lives. And if you're going to do drugs, don't go and purchase firearms. And if you do attempt to purchase a firearm, at least put the truth on there so that the onus is on the person selling you the firearm, not directly on you. I know some people are going to be upset by that, but listen, that was the breaking news of the day as it relates to the crime world, so to speak, what's going on in the court system, and to ignore it, well, that'd be a little disingenuous. Next, the Karen Reed trial. That got a little awkward. Took a little bit of a turn on Monday as the Massachusetts state trooper who led the investigation into her then boyfriend's death was forced to read his text messages disparaging the suspect, Miss Reed. In the messages, Lieutenant Michael Proctor called Miss Reed a whack job. He used a word that rhymes with punt and referred to her as a babe with no ass, while also making light of her Fall River accent. In other messages, he joked about rummaging through her phone for nude photos during the investigation. And Reed's defense attorneys claim these texts support their theory that Miss Reed was framed by police in a vast conspiracy to blame her for her boyfriend, John O'Keefe's death back in January of 2022. However, Lieutenant Proctor claimed that those juveniles' unprofessional comments had zero impact on the facts, the evidence, and the integrity of his investigation. Now, as you may recall, Mr. O'Keefe was found unconscious in a snowbank with a skull fracture, swollen eyes, and hypothermia at about 6 a.m. on January 29th of 2022 outside of a house where Karen Reed claims that she dropped him off for an after party about 12:45 a.m. Mr. O'Keefe was then taken to the Good Samaritan Hospital in Brockton, Massachusetts, where he was pronounced dead several hours later. Police have since alleged that Miss Reed hit Mr. O'Keefe, a 16-year Boston cop, with her SUV and let him die after a night of bar hopping and heavy drinking. Now, the two, Reed and O'Keefe, had gone out to celebrate the acceptance of his niece into a private school, and footage from one of the bars, C.R. McCarthy's in Boston, showed her, Karen Reed, embracing Mr. O'Keefe, hugging and kissing the man she is accused of later killing just a few hours later. But prosecutors claim that Miss Reed and Mr. O'Keefe's relationship had been on the rocks amid allegations he was cheating and tensions over the two children in O'Keefe's care, his orphaned niece and nephew that he was caring for. Prosecutors further allege that fragments from her car were found near O'Keefe's body and are proof that Reed backed her SUV into Mr. O'Keefe. Now, prosecutors have also alleged that witnesses at the scene heard Miss Reed yell, "I hit him," when she and two friends found his body along with, "This is my fault. I did this." Reed's defense attorneys, however, claim that's just simply not the case, and that they were able to get the police to acknowledge that they never actually heard her say she hit Mr. O'Keefe. Defense attorneys further rebutted the idea that the relationship had trouble, with O'Keefe's friend at the bar testifying that the couple seemed very content the night in question. Quite the contrary, they claimed that O'Keefe was beaten up by people at the party and thrown outside, where he ultimately died on the lawn. Now, the defense argued that the police did not then properly investigate O'Keefe's death and have singled out Lieutenant Proctor for his close relationship with a number of the law enforcement officers connected to the case, including the homeowner, Brian Albert. In fact, in one of those text messages read in court, Lieutenant Proctor replied to someone inquiring whether Albert would receive any repercussions by saying, "Nope, homeowner is a Boston cop too." Anyway, after Reed was charged with O'Keefe's murder, Proctor's sister also texted him to inform him that Albert wanted to buy him a gift. But Proctor testified that neither he nor his wife received any gift from Albert or his wife, a friend of Proctor's sister. Other messages revealed that Lieutenant Proctor texted friends that there will be some serious charges brought on the girl, referring to Miss Reed. And he claimed in the messages that Reed was waffling him and that she hit him with her car, according to the Boston Globe. Now, we're going to lock this whack job up, read one of the messages. Now, on the stand, Lieutenant Proctor repeatedly apologized for the text messages, calling it poor language, and it had no bearing whatsoever on the investigation. Now, one could argue if you're making those kind of statements, you're not really focusing on the facts of the investigation, are you? Particularly when it relates to your friends. I guess even more importantly, why would you be revealing the facts of that investigation while the investigation's ongoing to people that are potential witnesses in the case? Anyway, the lieutenant is also facing an internal investigation over a potential violation of department policy, like, I don't know, talking about investigations with others. Just saying. Anyway, testimony in Reed's trial is expected to resume on Wednesday. Why? Because they don't do anything in Boston, apparently, more than one day. Unbelievable. Did you notice in the Hunter Biden trial, they started on a Monday, they ended on a Tuesday. When everybody was done, they just moved natural progression to the next phase. I don't get it, what they do on the East Coast. They're in Boston. Apparently, federal court's a little different. But things are a little weird, too, down in Georgia, where Young Thug's attorney gets arrested. This is crazy, ladies and gentlemen. This is crazy. So Young Thug's racketeering trial that will never end took a twist yesterday when the defense team was thrown in jail for the next 10 weekends for refusing to tell the judge how he heard about a private conversation. So here's how things started. The attorney for Young Thug, a guy by the name of Brian Steele, somehow learned of a conversation that was between the judge, this Judge Glanville, prosecutors, and Kenneth Copeland, one of the state's star witnesses in the case against Young Thug. Well, Steele and Glanville got into a heated little argument in open court, starting with the defense attorney, Steele, confronting the judge about this alleged secret meeting in the judge's chambers on Monday morning. So, like I said, he somehow learned of this conversation between the judge, the prosecutor, and this key witness. All right? That's weird because it completely copied it over again. The judge said the talk was ex parte. Now, ex parte means one-sided. The prosecutor, apparently there, with the key witness. For a witness who's already started to testify, that should not be an ex parte communication. Okay? So only one party is involved. And rarely is something done in the court system ex parte. You can try to go get a restraining order ex parte, but eventually the other party is going to get notice of it. And you get to see exactly what the person put on the application. You could try to go get seized property ex parte if you think it was fleeing, but normally they say, no, well, let's just wait and see. So ex parte in the court system is not done. You don't send ex parte emails to the judge. You don't have ex parte communications if you're talking about a case unless the other party is there. Anyway, we go on. But Mr. Steele argued that Young Thug and himself had a right to be in that meeting under the Georgia Constitution. I agree. Anyway, Mr. Steele wanted to know what happened in the meeting, but the judge quickly redirected the conversation back to Mr. Steele, asking him how he found out about the meeting. And the attorney said, I'm not telling you. Now, I don't know how he found out, but my guess is probably a clerk said, there may be something you want to know about. Anyway, the judge said, I'm asking you, how did you get this information? And the court said, and Mr. Steele said, I'm not telling the court. The conversation was a dead end from there, and the Judge Glanville ordered the bailiff to take Mr. Steele into custody. You got some information you shouldn't have gotten, the judge told Young Thug's attorney. You're not supposed to have communications with a witness who's been sworn, Steele said, which is true, referring to Copeland, right, who was in the ex parte communication. Anyway, Steele was ordered to report to the Fulton County Jail by 7 p.m. Friday for 10 weekends for a total of 20 days. Unbelievable, ladies and gentlemen. Unbelievable. So, like I said, at the opening statements in this case, it started back in November of 2023. And prosecutors alleged that Young Thug, whose real name is Jeffrey Lamar Williams, used his record label Young Stoner Life as a front for Young Slime Life, a street gang affiliated with the LA-based Bloods gang. Racketeering refers to acquiring a business illegally, running a business with illegally derived finances, or using a business to break the law. Essentially, the claim is that Young Stoner Life and Young Slime Life were one in the same. Now, this YSL gang has allegedly recruited the young people from around Young Thug to commit crimes of murder, assault, carjacking, drug dealing, and car thefts going back as far as 2013. Now, Young Thug was arrested in May of last year in an upscale neighborhood in Atlanta and has remained in custody ever since. The original indictment against the gang members, including Young Thug, is a wide-ranging list of 181 crimes that the prosecutors say were committed as part of the alleged racketeering case, which stands for RICO, which is Racketeering Influenced and Corrupt Organization, conspiracy to further the gang's interest. Now, Mr. Copeland, also known as Little Woody, was signed to Young Stoner Life as a rapper and spent the weekend behind bars after refusing to testify on Friday. Copeland initially didn't want to testify, and keeping with his reluctant attitude, he dodged most of the prosecutor's questions before Monday's lunch break, which is when Steele said he learned about the conversation that ultimately got him tossed into jail by Judge Glanville. Remember that name, ladies and gentlemen, Judge Glanville. Now, once Mr. Steele, the attorney, was removed from the courtroom by officers, Young Thug's other lawyer, Keith Adams, said he didn't want to continue the trial without Mr. Steele. And the judge, the statement was made, you are removing me against his will, my will, and you're taking away his right to counsel, Steele said as he was being escorted out of the courtroom. Glanville responded by saying he doesn't have that luxury, ordering him to defend his client without the help of Mr. Steele. You don't get to extort the court, the judge said. It doesn't work that way. He added that the information leaked was a violation of the sacrosanctness of the judge's chambers. Anyway, Steele was eventually let back into the proceeding at the insistence of the lead prosecutor, because the prosecutor knew what the judge was doing was going to result in a mistrial and reversal on appeal. Then another lawyer representing one of the other co-defendants in the case asked the judge, hey, can we get a transcript of that conversation that was had between the prosecutor and the witness who had already been sworn in? Anyway, the judge denied that request. But guess what? The cavalry comes in. A woman by the name of Ashley Merchant, who is the president of the Georgia Association of the Criminal Defense Lawyers, said that she is going to represent Mr. Steele in an effort to get him released from custody and get the contempt vacated. Now, Ms. Merchant has been representing lawyers found in contempt for at least 10 years as part of her legal group's strike force team. It's not uncommon for a defense bar to have a strike force when somebody comes after them. We had an attorney thrown in jail once. The judge couldn't believe it. I just couldn't believe it. She didn't like the attorney's answers and threw him in jail for the weekend. Big mistake when he was just one of the most connected people in the entire state. Big problem. Anyway, Ms. Merchant said, hey, we are not okay with this. We're not going to let this happen to our brother, who was simply there doing his job. And this is not how advocates should be treated. It's hard enough being a criminal defense attorney, and we shouldn't be threatened with jail at every turn. So when she arrived at the courthouse along with 12 other attorneys, they asked Judge Glanville to recuse himself from Mr. Steele's contempt case. Anyway, little twist in the Young Thug case, and guess what? It's supposed to go through 2025 because they hold court for like 4 hours, then a day or two here or there. I don't understand how anybody could run a law practice, let alone try a case under that scheduling. I've never seen anything like it till recently. Don't understand it. Don't see how it works. Because remember, jury selection began in January of 2023, and that took 10 months. Does anyone not have any consideration for jurors in this particular case? Anyway, next on the docket, Barry Morphew's prosecutor is going to get her day in court. Now, you may say, where is this taking place, Scott? Well, it's taking place at the Denver courthouse in Denver because the chambers for attorney regulation people, it all has to be redone because somebody got into the offices. Somebody broke into the office and turned on the fire alarms and ruined all the state employees' offices that are related to the court system many months ago. So this is taking place in a courthouse at the Lindsay Flanagan Courthouse in Denver. So as you may recall, the district attorney who brought charges that were ultimately dismissed against a Colorado man, Barry Morphew, who was accused of killing his wife, is facing a disciplinary hearing that could ultimately lead her to getting disbarred. Now, the 2-week hearing is being held to determine if the 11th Judicial District Attorney, Linda Stanley, violated attorney conduct rules in the prosecution of Barry Morphew, as well as any other case. Now, Stanley's lawyers state that the state doesn't have clear and convincing evidence that she did anything wrong. Remember, preponderance of the evidence, more likely than not. Clear and convincing is, higher standard than that. And then you have proof beyond a reasonable doubt, the highest form of proof. So the prosecutors have to prove by clear and convincing evidence to a disciplinary judge that she violated the ethical rules. Now, in a disciplinary complaint filed back in October of last year, the Office of Attorney Regulation Counsel detailed alleged misconduct by Ms. Stanley, including interactions between her and a true crime YouTuber, Mike King, who we saw at a CrimeCon and took a picture with him. And it was good to catch up. Anyway, those interactions include text exchanges, interviews, and video comments Stanley allegedly made on King's YouTube channel before, during, and after Mr. Barry Morphew's prosecution. Now, a panel will decide whether Ms. Stanley violated the rules, and if so, what her punishment should be. The most serious punishment, should she be convicted, would mean losing her law license and her ability to practice law. Now, as you may recall, prosecutors dropped charges against Barry Morphew in April of 2022 after the judge barred the prosecution from calling key witnesses because the prosecution failed to turn over proper discovery. The charges were dropped without prejudice, meaning that obviously Mr. Barry Morphew could be tried again if the prosecution thought that they had new evidence that they could bring their case against Barry Morphew. He has not been charged, and obviously we give him the presumption of innocence like anyone that we talk about on this show, unless they have been convicted by a jury or pled guilty. Next on the docket, another Parent of the Year contestant. A man has been charged after deputies found drugs and guns during a vehicle search, including a bag of meth that one of his juvenile children was hiding. So on June 6th, deputies with the Upshur County Sheriff's Office pulled over a vehicle in West Virginia near the Arlington Mini Mart because it had very dark windows, tint on the windows, and a loud exhaust. That's a reasonable suspicion to pull somebody over. Anyway, the driver was identified as Kenneth Cutright, and there were two juveniles in the car, ages 12 and 14, in the back seat. Now, the information that Mr. Cutright gave for the vehicle didn't match the registration insurance, and the inspection sticker determined it to be fraudulent, according to the deputies. Deputies also learned that the vehicle had been reported stolen in Ohio. Anyway, Mr. Cutright knew nothing about any stolen cars from Ohio and stated that, my gosh, I traded this car for the Hummer, the big truck kind of Hummer. But, we didn't get around to signing all the title paperwork, so I don't really understand how, this car is stolen. I don't get it. Don't understand it. Heard 1,000 times. Read it 1,000 times in police reports. Anyway, after deputies asked Mr. Cutright to exit the vehicle, he was asked if he could get back in because of his children in the back seat. And the deputy said when they asked Mr. Cutright if there was anything illegal in the vehicle, he said there was not anything illegal in the vehicle, but told deputies that they could not search his car. Anyway, officers allowed the juveniles to wait outside the vehicle for someone to pick them up, and Cutright hovered around the kids, putting his back to the deputies, which led the deputies to believe that Cutright may have concealed something on his own kids. Deputies then performed a search of the vehicle and found a meth pipe and a loaded 9mm pistol. And after someone came to pick up the juveniles, deputy questioned one of the children about the other object in her hoodie. And the girl told the deputies, "It's just a bag." Well, after the daughter started crying and Cutright told her to get in the vehicle, the deputies were able to speak with her and received the bag, which contained meth. And not just a little bit of meth, 7 ounces of meth. Little more than recreational use. That's definitely possession with intent to distribute kind of quantities, ladies and gentlemen. Hence the reason why Mr. Cutright has been charged with child neglect, creating risk of injury, being a prohibited person, i.e. a felon in possession of a firearm, and possession with intent to deliver a controlled substance. Needless to say, he is being held at the Tigert Valley Regional Jail, where he is probably going to go do some prison time, ladies and gentlemen. And next, our dumb criminal of the day. Take a look at this video. It's been going around on the internet, but it just shows you. Look at this woman and her friend. They were apparently throwing eggs at a house before they were served a little bit of karma themselves. As you can see from the video, as soon as these two flee the scene, one of the women frantically drove the black SUV past the stop sign and immediately crashed it into oncoming traffic. This unidentified woman, we don't know if they were injured or if everybody's okay, but it just kind of shows you, ladies and gentlemen, if you're out there vandalizing somebody's property with an egg, by God, at least make sure to stop and look all directions before pulling into that intersection. Unidentified egg thrower, you are our dumb criminal of the day. Congratulations, you made it. That's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. Join us tonight, 6 p.m. Mountain Time, for our Patreon show immediately following that. And remember, the Constitution matters.